Good evening and welcome to the Ombudsman program. My name is Diane Welborn and I am the Ombudsman and I'm going to be your host for this evening's program. I'm delighted to be able to bring to our viewers this evening the Chief Ombudsman for the Ohio Workers' Compensation Program. Joining me tonight, having driven over from Columbus, Ohio, is Ombudsman Beryl Piccolantonia. So thank you so much for coming to the program tonight.
Thank you for having me.
I'm so glad you're here. Many of the citizens of Montgomery County I know have utilized the services of workers' compensation. We have workers that utilize those services and we have employers that contribute to those services. So tonight I have a lot of questions for the Chief Ombudsman and you are welcome to call in with your questions as well. So let's go ahead and get started. For those that might not have had much experience with your division and with your offices, please tell us a little bit about the history of workers' compensation in Ohio.
Sure. I will say that workers' compensation, the beginning of workers' compensation in Ohio was in 1912. That is when Ohio's Constitution was amended to authorize the enactment of a workers' comp system for the state. Prior to that, an employee had the opportunity to go into court, but they had to show negligence or fault. And the cost of, those actions was pretty much borne by society as a whole. In 1912, the Constitution was amended and it authorized the General Assembly to establish a workers' comp program and to enact the laws to establish, administer, and regulate a state fund that was designed to compensate workers and their dependents for injuries that they incurred in the course of their employment. In January of 1914, employers with 5 or more employees were required to participate in that workers' comp program. And then again in January, but this time in 1924, the system was expanded and all employers who had 3 or more employees were required to participate in the system. There were no major changes really to Ohio's workers' compensation system again until July of 1972. So that was quite a number of years that went by. Yeah. But in July of 72, the National Commission on State Workers' Compensation Laws issued a report. And that report had comprehensive recommendations related to all of the state's workers' comp programs. In response to that report, the Ohio General Assembly then enacted its own major reforms in 1973 and 1975, and it was at that time that all employers with 1 or more employees were required to participate in the workers' comp system. That reform legislation also eliminated monetary limitations on temporary total disability benefits, and it increased benefit levels across the board. That also happens to be around the same time that the Ombudsperson, it's called Ombudsperson in the statute, but the Ombudsperson program was created around that time. So that's, I guess that's kind of the history of workers' comp in Ohio. The idea behind having a workers' compensation system is that rather than society as a whole bear the cost of injury in the workplace, the theory is that that cost is better borne by employers and not individual employers when an injury occurs, but instead spread across employers. And in exchange for that, employees gave up their right to sue the employers. I guess essentially the employees got certainty and speed in exchange for a less than a full recovery for the injuries that they sustained. So that's the workers' comp bargain. I don't know if anyone's ever heard that term before, but that's the bargain that gave birth to the workers' comp system in Ohio.
Well, fascinating, very interesting history and how it started so early back in 1912,
Right.
when we had, a century ago, we had different kinds of work, different types of
Yes.
everything 100 years ago than what we have now. Since it was in 1912, is Ohio one of the earlier states, do you know?
I don't know that.
Okay, that's
I don't
all
know the
right.
answer to
Okay,
that.
that's fine. But it's been evolving and
Yeah.
growing over time. Okay, that's great. Thank you for that background. Would you like to kind of reframe a little bit when we talk about the mission of the of workers' compensation and as the office stands today? It was at that time to achieve the important goals of providing compensation for
Right.
workers, but also spreading that responsibility over a larger pool of employers. What would you like to address our modern day mission of the workers' compensation in Ohio?
I can tell you what the Bureau's stated mission is. The Bureau, so let me just back up a
Sure.
little bit, I guess.
That's fine.
There are two agencies really that are involved in the workers' compensation system in Ohio. There's the Bureau of Workers' Compensation, and that's the agency that I think most people are familiar with. There's also the Industrial Commission, and I don't know if we'll talk about the Industrial Commission at all later, but when the workers' compensation system first began, there was just the Industrial Commission. The Industrial Commission at that time was the agency that administered the workers' compensation system. So the Bureau of Workers' Compensation actually wasn't founded even until 1955. And that's when the administrative functions for the workers' compensation system were transferred from the Industrial Commission to the Bureau of Workers' Compensation.
Right, part of that long evolution. We have a phone call if somebody that has a question about it. You're on the air. We'd like to hear your phone call.
Yes, the history that was given of workers' compensation was so fascinating, and I'm just wondering, it seemed to me that the original legislation was constructed in support of industrial laborers, and now that we have moved to more of an information-based economy, has the initial legislation been adapted? Is it still relevant? And furthermore, I'm of the impression that Ohio's economy is still based to a certain degree on farming. And how does the legislation apply to farming? And finally, sorry to have so many questions, what about political changes? I have the feeling that workers' rights are constantly being eroded as political changes occur. And has the Ombudsman seen a weakening of the legislation, not by law, but simply de facto by political changes?
Well, thank you for those three questions actually rolled up into one, and we'll do our best to get them answered. Thank you for calling in. Okay. Do I need to repeat them, or did you?
I heard I remember the last question.
Okay.
The first
The
two.
first one dealt a little bit with the legislation and how over time there have been amendments, wondering if it has been, if it's keeping up. The second one, and the fact that 100 years ago, our workforce was in industry, industrial types of things, but it was also in farming 100 years ago.
Sure.
And we still, do have many farms today. Maybe
Right.
not as many, I'm sure, but we still do. And then the last question was about impact on workers, or the impact of changes on workers' rights.
Sure.
So let's start with this first one about the nature of jobs 100 years ago,
Yes.
and the amendment of the commission and the program.
Yeah, certainly the nature of work in the United States and in Ohio has changed over the years, and definitely it has changed since Ohio enacted a workers' compensation system. I couldn't tell you the dates of all of the various amendments to Ohio's
That's
workers'
quite all right.
compensation system.
Yes.
But I will say it has been amended quite a number of times, probably in an attempt to, for one of the reasons for the amendments is an attempt to keep up with the changing nature of the workforce. The composition of the workforce, the types of injuries that are sustained has changed over time. The workers' compensation system covers injuries and occupational diseases, and I would suspect that there were probably more occupational diseases contracted when the system was first enacted than today. I would hope that that's the case.
Yes.
I think that probably is the case. So I think that there have been a good number of changes to the law over the years in an attempt to try to keep up with the changing nature of the workforce and the workplace. The second question had to do with...
And we'll come back a
Okay.
little bit later in the program. I want to ask you, he
Sure.
asked the question about the difference between the industrial work and now
Oh.
the information technology.
Okay.
So I
Sure.
would think that even in the past 20 years, your office has seen many different types of claims
Yes.
for injury, but we'll come back to that
Okay.
when we get into
Sure.
your numbers about your
Okay.
claims
Sure.
volume. But the second part was about farming and the inclusion of the agricultural in our workers' comp. Is there any, or in compensation, is there anything to add special about them for
I
that?
can't think of anything off the top of my head that is, there is something that is unique about every type of work environment. I can't think of anything off the top of my head that stands out that is especially unique about farming as it relates to workers' compensation anyway. I can
Right.
think of lots of things that are unique about
Right.
farming,
Right.
but not specific to workers' compensation.
Okay, all right. And then finally, workers' rights and changes in workers' rights over time.
Sure.
Do you have a comment on those with respect to your work?
As there has been new legislation in the area of workers' compensation, as I said, some of that legislation is for the purpose of trying to keep up with the changing nature of the workplace and the workforce. But obviously, those changes are made at the General Assembly. So there are other reasons, too, why laws are changed. And I don't know that I can make a generalized statement about whether or not those laws have changed to lessen the rights of workers, but I think we've just gotten different issues in my office. From my vantage point, the type of issues that come to the Ombudsman's office, they're just different over time.
Well, we will come back then,
Sure.
and I'm going to ask some more
Sure.
about how those things have changed
Sure.
over time. Now, you are located in Columbus, but accessibility is to all workers and all employers in the state. So, talk a little bit about the presence of you and your staff around the state of Ohio, and accessibility for citizens and employers.
My office, the Ombuds office, the main Ombudsman's office, is located in Columbus, Ohio. That's where our physical office is. We do actually also have an office in Cleveland. We currently only have one staff member that is still working in the Cleveland Ombudsman office. At one point, there was an assistant ombudsman in the Cleveland office and a full staff, but over time that office has kind of shrunk. And I think with technology and the ability to reach people in different ways, the need to have a physical everyday presence has kind of consolidated itself in Columbus. Luckily, it is a central location, and I and some of my staff are able to travel around the state. So if there are issues that come up that require meeting with people in person, we have the ability to do that.
Good. Good.
Yeah.
So you come out and visit the
come out
public
and
where
visit
they
the
are.
public
That's
where they
good.
are.
That's
Yes.
great. Let's talk a little bit about what does workers' compensation in general cover. Let's
Sure.
talk about the kinds of things that are eligible.
Okay. So I think I had started to give you what the Bureau of Workers' Compensation's what their stated mission is, and I'll read that real quickly.
Sure.
It's a short mission statement, but I think it helps when I talk about the kinds of things that are covered. So the Bureau's stated mission is that it is the Bureau of. Sorry, I started in the wrong spot.
You're okay. That'll be fine.
Yeah, you know what? I don't think I have their stated mission written down anymore, but I'll just tell you what the Bureau of Workers' Compensation covers. So when an injured worker has a claim that is an allowed claim, it's determined that it is a valid workers' compensation claim. The Bureau will pay for all medical bills, including prescriptions, that are related to the conditions that are part of that allowed claim. So a workers' compensation claim is allowed for specific conditions, and they will cover any medical bills, any prescriptions that are directed toward the treatment of those allowed conditions. Additionally, there are several forms of compensation that the Bureau of Workers' Compensation will provide to an injured worker. The most common form of compensation, and usually the first form of compensation that's provided to an injured worker, is temporary total disability compensation. That is a form of compensation that it's not a full wage replacement, but it is a partial wage replacement that's intended to help offset the loss of wages when an injured worker is not able to work because of their injury or their occupational disease. If an injured worker, so the way that temporary total disability compensation works is that if an injured worker is off work for 8 or more calendar days, they become eligible for temporary total disability compensation. And as I said, it doesn't pay out at their full wages. It's not a complete wage replacement, but there is a calculation when a claim becomes allowed. I won't walk through the calculations, but there are 2 figures that are set. One is called the full weekly wage, and one is called the average weekly wage. And temporary total disability compensation is paid out at different rates. So, for example, the first 12 weeks of work that an injured worker misses, the Bureau or a self-insuring employer pays temporary total. It's at the rate of 72% of the injured worker's full weekly wage. After that first 12 weeks, then it is paid out at a rate of 66 2/3% of the injured worker's average weekly wage. And I think I said that an injured worker has to miss 8 or more days of work. However, if they're off work for 14 consecutive days, then the Bureau or the self-insuring employer goes back and pays those first 7 days of work, if that makes sense. It kind of works like a lot of employers' disability programs, I think, where there's an initial kind of waiting period, and then once 14 days are missed, then it'll go back and pay that early portion of time off work. So that's temporary total disability compensation. There are several other forms of compensation that are available depending on what the circumstances are. There's working and non-working wage loss. Those are different forms of compensation. There is something called living maintenance wage loss. There's something called living maintenance. There are there's permanent total disability compensation for an injured worker who is permanently and totally disabled.
It's the most severe
That is the
category
most,
of
yes.
determination, obviously.
Yeah.
Mm-hmm.
There are also scheduled loss awards, permanent partial awards. The Bureau may cover vocational rehabilitation for an injured worker if it's determined that they are eligible and feasible to participate in vocational rehabilitation. So the workers' comp system, either through the Bureau or, well, I don't know if we'll talk about self-insured employers at all, but or through the employer directly, they provide, I guess it covers all of those various things. And I think the one thing I left out was the most severe type of injury would be a death.
Yes.
There are also death benefits that are available to surviving family members. So.
Okay, all right. And with these many categories of different types of coverage, the worker, each of these determinations is made by the staff that receive the medical documentation.
Right.
Because individuals do not, as a norm, would not understand what exactly they're asking for
Right.
within all of
That
those
is right.
categories.
Yes.
So it's the documentation and the many codings that you use as that is
Yeah.
reviewed and analyzed by the professional staff.
Yeah, some of those forms of compensation do have to be specifically requested by a party. For example, an injured worker would have to request some of those forms of compensation. So when we talk about our office, that is the information is available to an injured worker who's interacting with the system to figure out what kinds of compensation they may be eligible for. But it's not always necessarily understandable to them what they may request.
Right.
And some of those forms of compensation, they're not just automatically provided, they must be requested.
Okay. I think we probably should ask for you to explain the difference between the state fund employers and, as you just mentioned, the self-insuring employers, and what's the difference, and roughly how many? I mean, what percentage of our employers fall into each of those categories?
Okay, sure.
Yeah.
So state fund employers, I think that's what most people probably think of when they think about workers' compensation. Most employers are state fund employers. Those are employers, they pay an insurance premium to the Bureau of Workers' Compensation, and then the Bureau manages their workers' compensation claims, kind of. The employer doesn't pay one of their employees directly for any of those things that I mentioned. The employer doesn't pay for the medical bills or the prescriptions or the forms of compensation. The Bureau of Workers' Compensation manages that. Self-insuring employers, that's a much smaller number of employers. It's typically larger employers. Those are to qualify for self-insurance, actually, they have to have a minimum of 500 employees. They also have to have 2 years experience within the state insurance fund, so they have to have been a state fund employer for 2 years. They have to be able to demonstrate strong financial stability. They have to have the ability to administer their own workers' compensation system, and they have to maintain an account with a financial institution in Ohio, and they have to be able to draw workers' comp checks from the same account as their payroll checks. So It's a much smaller number of employers who are self-insured.
Would you say it's at 20% or less than that even?
I should know
That's
the
okay.
answer to
That's all
that
right.
question, but I'm not sure. It's a small number. But those employers who are self-insuring employers, they essentially run their own workers' compensation system. They pay for and they manage their own system. They are the ones who make the first determination for anything that is going on in a workers' compensation claim. They decide whether or not the claim is compensable. They decide what conditions are part of the claim. They make the first determination about any medical treatments, any prescriptions, any forms of compensation. They handle all of that at the outset. And from the side of the worker, if there's a disagreement, if the worker, whether they have a state fund employer or a self-insuring employer, if the worker disagrees with a decision that gets made, or in the case of a state fund employer, if the employer disagrees with a decision that gets made, all appeals go to the Industrial Commission. And so the Industrial Commission is that other agency that I talked about. Even if a worker has a self-insuring employer, if they disagree with a decision that gets made, they have a right to have a hearing on whatever the issue is at the Industrial Commission.
Right. So that opportunity is still available even with the other. Well, let's talk a little bit about how the Industrial Commission is related to the Bureau. You mentioned that the Commission established the Bureau, or the Bureau became established with the Commission in the 70s. So what is their relationship today?
So at that time, when the Bureau, was created, the Industrial Commission became kind of the court system for the workers' compensation system. And the Industrial Commission, it is just that. It's the judicial branch of the workers' comp system. In a state fund claim, any employer or any injured worker who does not agree with a decision that gets made at the Bureau can have a hearing at the Industrial Commission. And in a self-insuring claim, if an injured worker doesn't agree with what their employer is doing, they have the right to have a hearing at the Industrial Commission. The Industrial Commission has 3 levels of hearings. There are district hearing officers. That's the first level of hearing. Then there are staff hearing officers, which is the second level of hearing. And then there are 3 commissioners. That is the third level of hearing. The Industrial Commission, I looked at their website before I came here today. It says that they conduct over 150,000 hearings annually. And most of those hearings are within 45 days of the original claim appeal. So they move pretty quickly. They have hearings. I don't know if you want me to talk about what those hearings are and how those different levels work, but most hearings begin at the district hearing officer level. There are a couple kinds of hearings that start out at the second level, the staff hearing officer level, and those would be permanent total disability, and there's something called a violation of a specific safety requirement, which I am not going to explain right now. It's kind of complicated, but those start out at the second level, the staff hearing officer level. In fact, those 2 issues don't even get decided at the Bureau. They go straight over to the Industrial Commission for a decision.
And is the injured worker receiving some assistance while this process is going?
That's a good question. Injured workers and employers at any point when involved in a workers' compensation claim have the right to be working with an attorney at any point in the process of interacting with the workers' comp system. And that, like I said, that's employers and injured workers. Oftentimes, employers have somebody helping them manage their workers' compensation system. Usually it's like a third-party administrator who is assisting them manage their workers' compensation system. And even at the point that they may have a hearing at the Industrial Commission, those people functioning in the role of a third-party administrator can assist employers a lot of times with hearings, not always. There are a lot of smaller employers who don't have anyone really helping them out. But attorneys are not provided, but like I said, any party can work with an attorney at any point if they feel like they need legal representation. And I think that employees, anyone that somebody would talk to at either agency, the Bureau or the Industrial Commission, make sure that customers are aware that they have that right. A lot of times, especially the customers that we're dealing with, for whatever reason, are not working with attorneys. We do work with a good number of customers who are working with attorneys, but there are also a good number of people who are not. It's not required at a hearing that you have an attorney. There are plenty of hearings that go forward with unrepresented parties. Industrial Commission hearings are supposed to be informal hearings. It's not an actual judicial proceeding.
Right.
It's an administrative hearing, but they are conducted. They're presided over by a hearing officer who is an attorney. I mean, the atmosphere it's not quite this casual. So sometimes people don't feel comfortable going to a hearing without a legal representative.
Right, so they choose to get that. Or,
Yeah.
Mm-hmm. Certainly, of course. So that while this hearing process is going on, there's not really any benefit to the worker until the decision is made. Is that correct?
It depends.
Okay.
Any kind of issue can go over to the Industrial Commission for a hearing. So if we're talking about the initial allowance of the claim, and if that initial decision at the Bureau or by the self-insuring employer was to deny that claim, then that would be correct. There are no benefits that are getting paid until that first level hearing occurs at the Industrial Commission. And I started to say that that first level, that's where most issues begin. Anybody has a right to Any party to the claim has a right to appeal that first level decision if they disagree with it, and they are entitled to a second level staff hearing officer hearing. It's a de novo hearing, which is basically as if the first hearing never happened.
It's a fresh new
It's a
hearing.
fresh start,
Yeah. Mm-hmm.
yes.
Yeah.
So that they are entitled to. If they disagree with that second level decision, they can file an appeal to that decision also, and that would go to the third level, the commissioner level hearings. Those appeals are discretionary. So there is no guaranteed right to a third level hearing in front of the commissioners. Last I heard, I think about 2% of appeals are accepted to be heard in front of the Industrial Commission commissioners.
Mm-hmm.
So it's a small number that get up to that third level.
Right. Are you seeing, or does the Industrial Commission see approximately the same number of employers and workers coming in for hearings or requesting hearings, or is it kind of evenly split, or is it predominantly employers or predominantly workers?
I think it's probably pretty evenly
Mm-hmm.
split.
Mm-hmm.
Yeah.
Mm-hmm.
I would probably have to confirm that with
That's
the
all right.
Industrial Commission, but my feeling is that it's probably pretty evenly split. There may be more appeals filed by employers simply because maybe they're more aware of their rights to file those appeals, because they are working with, if not an attorney, like I said, they've got somebody managing their workers' comp system.
Guiding them.
Yeah.
Exactly, yeah. Well then, let's turn our attention a little bit to the establishment of the Ombudsman's office for Ohio workers' compensation, also back in the 70s, is that correct?
That's right.
Yeah, that's good. And talk a little bit about how that came to be.
My understanding is that, and I'm going to back up a little bit. I came into this position about a year ago. It was December of 2013. And as somebody who just kind of naturally is interested in history, one of the first things that I did was ask if we had all of our annual reports going all the way back. The Ombuds office, or me actually, I am responsible to issue a report every year.
To the commission, or to the governor, or to?
That report is required to go to the nominating council who appoints the chief ombudsman. Whether it is shared more broadly.
That's a part of the commission.
That's a part of the, yeah.
Okay.
And sometimes those reports are shared more broadly than that. At the time the office was established, it was a different board that appointed the ombudsman. It was a board that kind of reported to the legislature, so those reports were shared more broadly with the legislature at that time. But when I came into the office, I wanted to see to get my hands on all of the annual reports, because I didn't know a better way to kind of get the history of the office, who had been in there, what kind of issues they had dealt with, the structure of the office. So I was able to find annual reports going all the way back to 1977. At that time, the legislature kind of established the office on a temporary basis. And then in 1978, the office was permanently established. And we do have reports, like I said, that go all the way back to 1977, which I think is kind of neat.
It is. And so, today, it is this nominating board that selects the ombudsman, and to whom the ombudsman produces a report. Is that report also public?
It is public.
Okay.
It's not required to, well, it is a public record, so it's required to be public, but by our choice, we also put links to those annual reports on, I guess at the Bureau of Workers' Compensation and the Industrial Commission honors my request and past ombudsman's request to put copies of those reports on their website. They're provided upon request. So yeah, they are public documents.
Okay, all right. Now, talk to me a little bit about how many staff are in your office and working on these issues.
Currently, as I said before, most of our staff is in Columbus. So there is me, and then I have an administrative professional who she keeps the office running. She helps greatly in the production of the annual report. So that is one staff member, and then there are.
I'm going to ask you to hold that thought, and we'll come back to that. We have another caller. So, thank you. We'd like to hear your question.
Oh yes. Good evening, and thanks for your show.
Thanks for watching.
Her working nowadays on green homes and on bigger OSHA sort of construction, commercial construction. And I was wondering, I work for a very reputable firm. I know they would cover, anything that happened while I was on the job. But I was wondering if you could tell me a little bit more about my workman's compensation in the residential field and in the commercial field, and what is the status for me currently? Thank you very much.
In construction.
Have a great evening.
Thank you. Okay. We have a young person working in construction,
Sure.
wanting to hear what your comment would be for what's available for him, I gather. Yeah,
Yeah.
thank you.
I mean, what would be available to him would be the same thing that would be available to any other employee in the state of Ohio. Now, I'm going to pause just a moment because I think he said he was in the construction
Yes,
industry.
that's what I heard as well. Yeah.
One of the unique issues that does sometimes come up in the construction industry is the issue of independent contractors, subcontractors, that kind of thing. In order to be eligible for workers' compensation, an individual needs to be considered an employee. So in the arena of construction, there is sometimes a need for a legal determination about whether or not that worker is an employee rather than an independent contractor. And there is also often disagreement, or I don't know if there's a better word than that. There is sometimes disagreement between the employer and perhaps the Bureau about whether or not that worker is an independent contractor or an employee. Sometimes that's actually one area where it's probably really good that employers are working with somebody who's advising them, a third-party administrator or an attorney or something, so that what they believe that they have established is actually what they have established.
Right.
Sometimes they think they have independent contractors, but they really have employees.
Yes, that can become complex.
Mm-hmm.
Well, to take the young caller's question a little bit further, if the person is unsure whether about any of these things, of course, the first place to ask is the employer.
Yes.
But the person might be reluctant, and if you're on
Sure.
a construction job and you're out on a site, are they required to have all of the postings that offices are
Yes,
required to
they
have
are.
on site?
They are.
Okay. So where else would a worker, if a worker's looking around and trying to check out coverage, what else could they do to find out about their status? What would you suggest?
Yeah, I mean, what I would suggest is what you said at first, which is definitely a conversation with the employer, whoever it is that hired them, whoever it is that is supervising them, to have a conversation with them. If they feel like, if that worker feels like they still have questions, and maybe they do, and they want some more information, they can certainly call our office.
Okay.
That's one place that they could
Okay.
call.
Good.
They can also call the Bureau.
Right.
Now, if it's a self-insuring employer, they may not be able to get as much information. I mean,
I understand, because they're running their own.
Right.
They're running their own program.
Right.
But name and social security number
Yeah.
for a worker would be
Sure.
something that your office could check. Okay. Well, I
Yes.
hope that's helpful for him. And you were describing your staff.
Yes, that's right.
The staff that
Yes.
that the citizens are going to talk to when
That's
they call
right.
your office. So please go ahead.
So the people that my staff who directly handles most of the issues that come to our office, we call them agents in our office.
Agents.
That's what their title is. There are, and I'm counting, there are 5 of them. We've got 4 in Columbus, and then there's 1 that is in Cleveland. And then there is a supervisor that they have, and the supervisor, that's who they staff their more complex cases with, actually either with her or with me. So that's our staff.
That's great. What's your annual budget?
I had to go and
Approximately.
look. Actually, well, it's some of the numbers. When I was thinking about what we were going to talk about today, we run on a calendar year.
Yes.
So we're wrapping up all of our information for last calendar
Yes,
year right
yes.
now. So our budget for 2014 was, I'm looking, I think it was right around Sorry, give me just a second.
Okay.
It was $602,304. I didn't want. I had looked it up, so I wanted to give you that exact
You're being
number.
very precise.
Yes.
Thank you.
That was.
And overall, as you're wrapping up, or maybe you want to speak about 2013, if
Sure.
you're still wrapping up 2014, as most of us are, annually, about how many complaints make their way to the Ombudsman office?
And
Because you have that
yeah.
whole other hearing process that we've just talked
That's
about
right.
with the Industrial Commission, but right to your office, to you and the 5 agents, how many complaints make their way to you?
Well, I was able to get the numbers for 2014. Well, I have approximate numbers for
sure.
2014. I don't have
Of
exact
course,
numbers yet,
of
but it
course.
looks like we count the number of customer contacts and then we break that out. So we had right around 10,000 customer contacts in 2014. So of those 10,000 customer contacts, there were just about 1,200 of those that my office staff deemed to be complaints. So we break our customer contacts into complaints, ombuds inquiries, and then all other inquiries. So there were around 1,200 that we considered to be complaints. And as far as inquiries go, there were right around 3,200 that we considered to be ombuds inquiries.
So there's a lot of people contacting
There are a
you,
lot
for
of people
sure.
contacting us, yeah.
Yes. And so are some of those inquiries then a question about this somewhat complex Bureau and Industrial Commission process that you can just, oh yes, this is your answer, and you can tell them that this is what they need to know with regard to whatever their concern is, and then that's completed? Is
Yeah.
that it? Okay.
Yeah. Not
It's
all of the
clarification,
inquiries are
yeah.
that simple.
I know.
But yes, some of the inquiries are people contacting us because they don't know what comes next. I mean, it's a simple question with a fairly simple answer that can be resolved right there on the telephone or however they chose to contact us, but it can be resolved kind of in that moment quickly.
And does your office then have access to the databases for in both of all of the agencies? So
Yes.
if the question pertains to a claim that has been filed, you all can see where it is
Yes.
within all of the system?
Yeah.
Is that a very frequently put
Yes.
question to you? Where am I in
Yes.
your system? Okay.
Yes. Yes.
Would you like to kind of give us like maybe the most frequent top 3 or whatever types of questions that you get?
So we get, our customers are comprised of really anyone who is interacting with the workers' compensation system. Sure. The bulk of our contacts are from injured workers and employers, but we also work with attorneys or other kinds of representatives, union representatives, third-party administrators. We also work with medical providers who sometimes run into issues getting medical bills paid. But our most frequent issues that come to the office from injured workers usually have to do with benefits that they are entitled to that are not being paid timely, or a medication or a medical treatment or something that is not being provided timely. That's the most common issue from injured workers. From employers, the most common issue usually has to do with their policy. Either they've gotten a charge on their policy that they don't understand, or maybe somebody new has taken over managing their workers' comp system and they really don't know what they're supposed to be doing. So that would be the most common type of issue that comes to us from employers.
And then do you also get calls that are complaints about the hearing process that you've described for us? Okay,
Sure.
All right. And how would you work toward resolution as from your office within that hearing process?
So what our office, one of the things that we try to do is first encourage people to utilize avenues within the two agencies that are available to them. And as it relates to the Industrial Commission, there is a hearing officer complaint process. So when that type of issue is brought to us, the first thing that we do is we provide them with that policy, kind of walk them through how it works, and we can even be the conveyors of that complaint if that's something that's helpful to them. So we will get that complaint to the proper person at the Industrial Commission. We will keep our case open until a response is received by the person who has filed the complaint, and then we'll follow back up with them to make sure that it has been resolved one way or the other to their satisfaction. Once they've utilized whatever that process is, and at the Industrial Commission, that's the process. There's also, I don't think I mentioned, the Bureau of Workers' Compensation has a self-insured department, and there is a self-insured complaint process. So that's another one of those internal agency processes that we try to guide people towards going through first. And then, as I said, we follow up with the individual afterwards to make sure that the issue has been resolved. And if not, that's when we would look into whatever the issue is further and try to work with the agencies to get some resolution so that there's some satisfaction. Now, obviously, not everybody is going to be satisfied with everything all of the time.
Of course.
And as it relates to hearing decisions, those, they kind of, the decisions themselves, the substance of those decisions have to follow that process. There is a right to an appeal decisions from the Industrial Commission out into the court system. And we can kind of assist with making sure people know how to do those things. But if it's a substantive issue like that, it has to follow that process.
And the Ombudsman does not become involved
Correct.
in attempting to overturn
that is correct.
A hearing decision.
Correct.
Yes, okay. When you've just kind of mentioned, you have just definitely mentioned that there are internal processes that you are going to direct citizens to, but for anyone watching the program tonight, what are some of the points where you say, we want you to call us, we want to hear from you so we can help fix this?
Sure.
What are some of those situations?
For the most part, we like for people to try to exhaust those internal avenues first. It's more effective for us to step in once those internal avenues have been at least attempted. But there are some kind of issues where contacting our office early would be a good thing. And one example that I would give would be an unrepresented employer or an injured worker who has a hearing scheduled at the Industrial Commission. Somebody who is not represented may not be aware of time frames for things like filing appeals and filing evidence and those kinds of things. So one method that we have of trying to reach out to those people is that we send letters from the Ombuds office to any unrepresented employer or injured worker who is having a first-time hearing at the Industrial Commission. We just try to make them aware of our existence, and those kinds of issues, I would encourage people to contact our office early.
That's very helpful. So you're reaching out to them, and
Yes.
you're saying, please respond to
Right.
us, so we can get you in with that. We don't have a lot of time yet, so I'm going to ask you
Sure.
for some short answers, if it's possible.
Sure.
We have older workers remaining in the workforce longer because of our country's financial situation.
Right.
People need to not retire maybe as early as they did. Is that impacting your work to any large degree, or not really?
I haven't really noticed much impact in the Ombuds office. I know that the Bureau of Workers' Compensation is trying to do some new, put in place some new processes at the early end of an injury where they're working with an individual's already existing primary care doctor to try to, because people are in the workforce longer, they may be coming to an injury with with pre-existing health issues. And I know that the Bureau is really trying to get their arms around that.
Okay, all right. And as you are in the Ombudsman's position looking at all of the different work that's going on across these very large, agencies, what type of issues are you bringing to the nominating board, and what can we look for to see in your annual report as things that where you would like to see improvement?
Sure. So I think I said earlier, this is I just completed, I guess, my first year.
Yeah.
And I was responsible for issuing an annual report covering the year that I was not in the office.
That's a challenge.
That was a challenge.
Yes.
And so that report did not contain any recommendations.
Understandable.
It reported data, but no recommendations. This report will likely contain some recommendations, but since I'm just still gathering that data, I'm not sure what those recommendations will be. But I would say I'm in really regular contact with both of the agencies. So recommendations do get made throughout the year directly to the agencies. I also issue monthly reports to all of the Bureau and Industrial Commission service offices, showing them when we find a complaint that's justified, they get some feedback from me on that complaint. So there is regular communication between my office and the agencies. But as far as what recommendations will be in the annual report, large-scale recommendations,
It's
I guess
under
we'll
development.
have to see
Yes,
in the
yeah,
spring when
yeah.
the report is issued.
Okay.
Yeah.
And before our time gets too far away, I'd like to ask you to give out your phone number.
Sure,
for us.
yes.
Okay.
And I'm forgive me, but I'm going to have to look for my phone number because I don't often call it.
Yes.
But we do have a 1-800 number, and that's the most frequent way that people contact us. That number is 1-800-335-0996. We can also be reached by email. We have an email address. It's Ombudsperson, OMBUDSPERSON, at bwc.state.ohio.us. There you can also, if anyone is in the Columbus area, they should feel free to actually come in and visit us. We're on the first floor right when you walk in the building. The address is 30 West Spring Street, and we're downtown Columbus.
Excellent. And on the website, there's a complaint
Yes, that was
form.
it. Yes, thank you. That's
Yes.
what I started to say. So on both agencies' websites, the Industrial Commission and the Bureau of Workers' Compensation, anybody should be able to easily find a link to our office. And any of that contact information that I just gave out will be there.
Right. Wonderful. That's great. We have very little time left. So is there something you'd like to get across to the public that I have not yet asked you?
Really, I guess I would just encourage anyone who has questions about workers' compensation, who has questions about the two state agencies that handle workers' compensation, call us. And if we're not the people who can help you, my staff will make sure that we get you to somebody who can help you out.
Okay, that's great. Thank you so much for joining me tonight and giving us all this good information about how workers and employers can get information from your agency and get questions answered and complaints resolved. So thank you. And thank you to the viewers for watching the program this evening. Good night.